Hello, everybody. Thanks for joining in. Let me start off with a very brief introduction about myself. My name is Karthik Putaya. I'm one of the founders of InvnTree. By education, I'm a mechanical engineer, a lawyer, a registered Indian patent agent, as well as a registered trademark agent. So I kind of started out my patent consulting or the IP career back in 2005, and thereafter we started InvnTree in 2010, and since then we have been providing IP services to a host of companies, starting from individual inventors to very large companies here in India and outside of India as well, catering to a clientele of well over about 500 clients spread across roughly about 30 odd countries. Okay, so the topic that we are discussing today is a fairly interesting topic, and there have been a lot of misconceptions around this particular topic, that is patenting of software inventions, specifically within India. Typical misconception is that software is patentable in US, but somehow it's not so patentable in India. So as such, outright, I would like to kind of state that that's a very large misconception. Software can definitely be patented in India. What we'll do next is look at some of the nuances in getting a software patented. What are the challenges? Of course, there are challenges in patenting software, and those challenges, some of them might be unique to India, but typically we could say that these challenges are there across the world, be it India, be it US, or be it Europe and other jurisdictions as well. Now, to get a strong foundation and build over that foundation, let's kind of look at the philosophy or the founding concept behind the patent system itself. Now, one of the primary questions is that why does a patent system even exist, right? And the key answer to it is that any country or countries across the world essentially would require constant development or constant progress in the fields of science and technology, right? Unless there is a constant improvement in these particular fields, it becomes extremely difficult for any humankind to evolve. So it is at the core of evolution that there needs to be some progress in science and technology, right? So when we say that there needs to be a progress in science and technology, there needs to be some kind of an incentive mechanism to actually, have people work on improving science and any field of technology. So what is that monopoly, right? So the monopoly is that if one were to come up with some improvement in some field of science and technology, then the country where one seeks protection would grant a patent, and if a patent gets granted, then that particular individual or that particular company who came up with that innovation gets a monopoly over that particular technology for a period of 20 years, right? So we had a situation wherein countries wanted people to work on improving science and technology, and in return, the governments established a system so that one could be incentivized to work on these things and make those improvements, and that incentives mechanism is the patent system itself, right? Now, what is the obligation? The obligation is that somebody who comes up with some kind of an improvement discloses the whole of the technology in the form of a patent document. Essentially, the person who wants that to get monopoly over that particular technology puts out all the information about that particular technology in a certain to a certain degree of detail in the patent document, and the patent office examines this particular patent application and the technology therein, and if it meets all the different criteria of a patent, then a patent would eventually be granted, right? Now the question is, governments want improvements in science and technology. Now, when we say that they want improvements in science and technology, now when we specifically speak of software, now the key question is software considered to be one of the fields of technology, right? So that is a key question that needs to be answered. Now, nobody would disagree that software is one of the key fields of technology. In fact, software is a technology, probably one of the fastest growing technology that is out there and that is probably known to anybody at this point in time. Software as a technology has extremely high impact. It has the power to actually disrupt many fields. And the one of the beautiful aspects of software as a technology is the application of this particular field into other fields of technology. So which means to say that software has applications across various other fields of technology as well, right? So it is very well established that software is definitely considered to be a field of technology, and thereby even software technology is something that can be patented. Moving on. Now, before we go into the detail, it's very good for us to probably look at the numbers itself to say that, okay, there is evidence, very well established evidence that patents relating to software inventions are granted even in India. Now, let's take the examples of various companies that are more or less purely acting in the software domain, and specifically with respect to India. Now, what the graph here shows is that starting all the way from MNC like a Microsoft, or MNC like TCS, probably based out of India, starting from Microsoft all the way to, let's say, Facebook. Each of these companies have hundreds to thousands of patents that are granted in India. They hold all of these patents within India. So, if one were to kind of look at evidence to figure out, whether there is any established evidence to say that software inventions are patentable in India or not, the thing is, there is very well established evidence, and this graph itself is a very good evidence to show that yes, software inventions are patentable, given the fact that most of these companies work in the field of software, and all of these companies have hundreds of thousands of patents that are granted within India. Apart from, even from a personal point of view, most of the projects even that we work on relates to software technology, and then we have, patents that more or less get granted to pretty much all the patent applications that we work on which relate to software technology. There are certain challenges when it comes to patenting of software, and then again there are some challenges in terms of patenting certain kind of software which some think are actually improvement in software technology, but they may not necessarily be an improvement in technology, right? Now, before we get there, let's look at what are the criteria to get a patent granted. Now, very broadly speaking, there are three criteria to get a patent granted. So if you have a technology, it has to meet the criteria of what is referred to as novelty, non-obviousness, and the third thing is being subject matter requirement. Now, coming to novelty, if the technology has some aspect that can be considered as new as compared to what is already there in public domain across the world, then that technology is considered to be novel. And essentially, novelty is judged based on what is known in public domain across the world. On the basis of that, right, what is known across the world is typically referred to as prior art. So in view of prior art, one checks whether there are some aspects of your technology that are not disclosed in this particular in these prior art references when considered individually. And if there is something new, then the novelty requirement is met. Moving on, non-obviousness requirement. Even the non-obviousness requirement is judged based on what is already known in public domain. That is, it is judged based on prior art. As compared to novelty, meeting the non-obviousness criteria is relatively harder. The reason being, in a non-obviousness requirement, the technology should be such that it should not be obvious to a person who has ordinary skill in that particular field in view of the combination of teachings of the prior art. Now, the difference between novelty and non-obviousness is that in novelty, it's a single reference or a single prior art piece that is compared against our technology, whereas in non-obviousness, it is a combination of prior art references that are considered to see whether our invention meets the non-obviousness requirement of patentability. Now this is fairly common, be it a software invention or be it an invention in a mechanical or a electrical or a chemical domain, be it whatever, these two criteria pretty much remain the same. Now the third requirement is what is referred to as a subject matter requirement. Now most countries, including India, provide a list of certain things which are not considered as inventions, and therefore they're not considered to be subject matter that can actually be patented. Right? Now, typically when it comes to software inventions, assuming that they meet the novelty requirement, which means to say that there is something new in that particular software technology, assuming that it meets also the non-obviousness requirement, which means to say that that software technology has some aspect which is not obvious considering what is there in public domain, the key challenge comes in the subject matter requirement, wherein one has to ensure that the software invention does not fall into one of those subject matters which are listed as not being patentable. Now we will get into subject matter requirement. Now, when it comes to the Indian patent law, there are multiple lists. There is a fairly exhaustive list as to what cannot be considered to be an invention, therefore what cannot be patented. However, when it comes to software inventions, among that list, there are certain aspects which are very, very critical. And it is on the basis of these aspects wherein there will be some challenges in actually patenting a software. We will go through each of these different challenges. So the four challenges essentially are what is called as mathematical method. Very broadly speaking, a mathematical method cannot be patented. Second, a business method cannot be patented. Third, computer programs, which is your source code, essentially cannot be patented. And lastly, algorithm cannot be patented. So these are the four criterias, or these are the four different types of subject matter wherein the patent office might pose challenges that your software invention probably falls into one or more of these different subject matters, and therefore your software invention cannot be patented. So that is where the challenge kind of starts coming up, right? So what we need to do is actually understand each of these different types of subject matter which are excluded from patenting. What we will now do is we'll go through each of them with examples so that one can very, very clearly understand what is patentable and what is not patentable. Now let's take the example of mathematical method. Now let's say you come up with a certain mathematical model. Now that mathematical model, let's say, is a new mathematical model that can calculate the shortest path between 2 points in a network of nodes. So let's say there is a network of nodes, and then every time the model gets an input saying that, okay, there are 2 nodes in this whole network, and we need to find the shortest path between those 2 nodes. Now let's say your invention or the crux of your invention kind of lies in that particular mathematical model itself. Now, this mathematical model that we are looking at can be applied in multiple fields, right? So which means to say that this mathematical model is actually not tied to any field of application, so to say. So if we were to try and protect this mathematical model itself, now irrespective of how innovative this particular mathematical model could be, you will not get a patent granted, because mathematical models as standalone mathematical models or mathematical methods or mathematical formulas cannot be patented. On the other hand, if the mathematical model is actually implemented in a particular application, then that becomes patentable. For example, let's say we integrate this mathematical model into a dynamic routing system for autonomous vehicles, right? Now, let's imagine a scenario wherein there are multiple autonomous vehicles, and these autonomous vehicles can move from one place to another, right? Now, let's suppose we have built in a backend system which can actually implement this mathematical model, and given the input of two places, the starting point and the destination, this mathematical model can be used to actually figure out what is the ideal route, what is the ideal route that this vehicle needs to be taken, this vehicle needs to take to reach from point 1 to point 2, and this system enables this autonomous vehicle to actually do that navigation. Then this mathematical model, in combination with this particular application, this particular very specific field of application, all of a sudden now becomes patentable, right? So the key learning here is that even when the innovativeness lies in the mathematical model itself, unless that mathematical model is tied to an application and we end up getting what is called as a technical effect or a technical result eventually, it does not become patentable. So once you implement this innovative mathematical model into a specific application, then it becomes patentable. Now let's take another example of mathematical models, right? Now, prime number factorization is another mathematical model that has a wide variety of applications. Typically, in a prime number factorization, you find prime numbers that multiply together to give the original number, right? So, and there are multiple mathematical models around how do you end up doing prime number factorization in a more efficient way, more effective way, so on and so forth. Now, irrespective of how innovative your mathematical model could be, how efficient your mathematical model could be in terms of prime number factorization, the mathematical model alone cannot be patented. But now let's say you tie this up or integrate this mathematical model of prime number factorization into public key infrastructure, and then package your patent application as something that is crucial, let's say in digital certificate and secure web transactions, so that this factorization is used in public key infrastructures, and you have implemented that into a specific field of technology, then it all of a sudden becomes patentable. So these are two distinct examples wherein the innovation itself could lie in the mathematical model, wherein the mathematical model by itself cannot be patented, but the moment you integrate that model into a specific field of technology, it becomes patentable. So I have a question here which says, what is a mathematical method? So like I said, a mathematical method could be a sequence of mathematical steps, or it could be a mathematical model, or it could be a mathematical formula as well, right? So any of these things could fall under the broad umbrella of mathematical methods. So like I said, pure mathematical methods standalone cannot be patented, but the moment you integrate that method into a specific field of application, a technical field of application, it becomes patentable. So when you are dealing with your own patent applications, when you are looking at applying for a patent, if you have a mathematical method that is core to your technology, then it becomes extremely important to actually integrate that into some field of technology while applying for a patent. Now, that field of technology could be a single field of technology, or when you're getting this patent document prepared, one could look at how do you make it more generalized so that it might apply to multiple fields of technology, at the same time not make it too abstract that we are trying to protect the mathematical method alone. Now let's move on to another category which is called as business methods. Now this is a very This is one of those subject matter requirements where lot of software inventions end up looking at challenges in terms of overcoming this kind of an objection, wherein we go ahead and apply for a patent, and the patent office comes back and says that what you are trying to protect is not a technology but a business method. Now, the reason why I say this is extremely important is because this is actually very, very common. So most of the times what we end up seeing, if we look at it from an Indian context, so most of the times what you end up seeing is that there is some kind of a business method or a business proposition, so to say, which is then implemented by way of software technology. Now let's take a very broad example of cab aggregation. So you have the likes of Ola, Uber, so on and so forth, who are into the cab aggregation business. Now, at the outset, one needs to realize that there were companies that were doing cab aggregation before as well, and there have been companies that have been doing cab aggregation now, and then there'll be a lot more companies who will end up doing cab aggregation going forward as well. The reason why everybody is able to pretty much follow the same business model, so to say, is because business models or business methods just cannot be protected, right? So let's say, irrespective of how innovative your business idea could be, business idea by itself cannot be patented. So in this very specific example, let's say you are building a cab aggregation app, then the cab aggregation app by itself cannot be patented. On the other hand, let's say you have built up a system, a pure software system, which probably takes real-time traffic conditions, driver availability, passenger demand patterns, so on and so forth, and essentially optimizes ride assignments and dynamically assigns routes, so on and so forth, right? So in this one, it is not the business method. Now we are speaking of very specific technology that takes in real-time data as input, multiple real-time data as input, and then eventually comes up with an output, which could be in terms of optimizing routes, optimizing allocations, so on and so forth. So something like this now becomes patentable, right? So many a times what we look at is, if there is a business method, irrespective of how innovative that business method is, now the underlying technology, whether one had to make changes to that underlying technology to enable this whole new business method, and whether that underlying changes that have been done to that underlying technology by itself is innovative or not, right? So the key learning here is that business models, irrespective of how innovative a business model is, cannot be patented, but the underlying technology can be patented. So in terms of from a more practical standpoint, for example, let's say both Ola also does cab aggregation, so does Uber, right? So the concept of cab aggregation cannot be protected by patent. But let's say the way driver assignment or the ride assignments or route dynamics, the underlying technology that is used by Ola versus Uber could be patented, as long as there are two different ways, two different approaches of doing it. No matter how nuanced a difference that might be, as long as that nuanced difference is novel and not obvious, it can be protected. Now let's take yet another example of business methods. Now, customer relationship management softwares are fairly common, right? So there are so many different customer relationship management softwares. Essentially, what these softwares end up doing is, essentially organizes and records, data with respect to customers, what are the different interactions with respect to those customers, the sales, revenues, where they are in the pipeline, so on and so forth, right? So this is again considered a business method, right? Because essentially you're just organizing data, and then you are putting a flow to that particular, the whole business process, as to we start off with a particular perspective, and then that prospective, we contact them. When we contact them, they move to the next stage of a sales pipeline, and if they are still interested, they probably move to a further stage in a sales pipeline, so on and so forth. So this is all a typical business method, right? One CRM could have, let's say, 10 stages, another CRM could have 20 stages, so on and so forth. So irrespective of all of this, so this is essentially a business model or a business method that is essentially implemented by a software. Now, irrespective of how innovative this business flow could be, if there is no underlying technology that is innovative, that business model cannot be patented. On the other hand, let's say we have built up a CRM system which kind of analyzes historic customer data, social media interactions, real-time behavior patterns, and probably, let's say, it also takes as input natural language and does natural language processing of feedbacks and queries. And using all of these things, now the system is able to route customer queries to a particular department and generate some contextual responses by considering all of these things. Now, what we are talking about here is pure technology. Although it is now implemented in a CRM, right, which is a broad business concept, but there is an underlying technology in that particular CRM software which would be considered as a patentable software invention. So right here in this very example, we saw that there is a software which pretty much plain vanilla CRM is built out. That is not patentable because that uses conventional software technology and just puts up a flow which can be defined by a certain business process. So what is new over there is not the software stack that built the CRM platform, but what is new over there is that business flow. So since the novelty is in the business flow, that software cannot be patented. On the other hand, let's consider that it is still a typical business flow itself, but in an underlying technology, you have a unique way of natural language processing and providing contextual response still fitted into the same flow, and because the underlying innovation lies in technology, this software invention becomes patentable. Now let me move on to another criteria where there could be some objections from the patent office, but this is a fairly straightforward criteria. And what we have seen is that in more recent times, this particular criteria is the usage of this particular criteria is gradually reducing. What this criteria is all about is that the Indian law says that computer programs per se is not patentable. Now, the important thing to highlight here is the per se part of it, right? Now, that has been included so that there is clarity with respect to this. So, which means to say that the computer programs. So, what are computer programs? Computer programs are essentially source codes. So, essentially, a computer program is a set of instructions written in such a way that a data processing system such as a computer can understand that particular language. So, that is what is meant by a computer program. If we try to patent the computer program itself, which is the source code itself, that is not patentable, right? So computer programs are as such protected as copyright, but within the realm of patents, it cannot be patented, right? So source codes cannot be patented, but what can be patented is what governs that source code itself, right? So that's the logic that governs that source code is something that is patentable. Now, the computer program that I've shown here, let's say it is a snippet of a source code that does natural language processing and then provides some kind of a sentiment analysis based on natural language processing, right? Now, the source code that actually does sentiment analysis by taking natural language as an input cannot be patented. However, the broader system itself, which has a certain set of logic in terms of how we take that natural language as an input, how we end up doing this sentiment analysis, using various aspects, and eventually getting a result in terms of the sentiment analysis can be patented, right? So computer programs or source codes by itself cannot be patented. It is something that is protected as copyright. On the other hand, the logic or the whole principle based on which those source codes might be written is patentable. And in fact, it is better off to actually protect it at that level rather than protecting at a lower level, which is the source code level, because the same logic could be applied by writing a different type of a program, right? So if one were to try and protect the computer program, even if it were to be patentable, would not be a very intelligent way of going about this, because source codes can be very easily worked around, but the logic that governs those source codes is very difficult to work around. Now let me move on to the last of these criteria, which is algorithms. Now this is a fairly tricky subject, but luckily we have a lot of judgments around this, which makes the topic fairly easier. Now, what is an algorithm, right? Now, algorithm is essentially a sequence of instructions a computer can execute is called as an algorithm. Now, typically when we talk about any software invention, the invention almost always is about those sequence of instructions which a computer is going to be executing, and as a result of which we get some novel output, right? So every software invention pretty much can be categorized as an algorithm. So let's consider what could be an algorithm that cannot be patented vis-a-vis what can be an algorithm that can be patented. Now let's assume that there is some kind of a sorting algorithm that can organize data in a specific order. Now, in here, what you see is that we are trying to protect the algorithm without any context of its application, right? So from reading this, we don't know what is the technical outcome of this whole novel sorting algorithm. So which means to say that we cannot really anticipate what is the technical effect of this particular algorithm. So if a patent were to be drafted without any context of how this algorithm is going to be used in a specific application, it becomes challenging. So it is very similar to the mathematical model or the mathematical method criteria that we spoke about. On the other hand, when we talk about a patentable software algorithm, so we are looking at, let's say, we had a similar sorting algorithm for dynamic optimization of network traffic in real-time communication networks, right? So it is still a specific set of instructions which a computer is going to execute, and it is going to be executing in a certain environment. And in this case, the environment is in the context of telecommunication. And as a result of this algorithm being executed by a computer, you are able to optimize network traffic in real time, right? Now we see that now this algorithm is actually reduced or integrated into a specific field of technology, and as a result of integration, you have what is called as a technical result of it, and that becomes patentable. So those kind of algorithms become patentable. Now the takeaway here is that be it mathematical method, be it business methods, be it computer program per se, or be it algorithms, at the end of the day, the question that we are trying to ask is that, was there a technical problem that had to be solved, and as a result of our innovation, are we getting what is called as a technical effect or a technical outcome, right? As long as we are able to present our invention in such a way that it solves a technical problem and eventually that results into a technical effect or provides a technical solution, it is very, very easy to get a patent, even when it is a pure outright software invention. So whenever you are looking at applying for a patent, you need to ask the question of, where does my innovation lie, right? If you feel that your innovation lies in some technical aspect. Although that technical aspect could be purely software, as long as your innovation lies or is trying to address a technical problem, and we are able to showcase that it is solving a technical problem and it results in some kind of a technical solution, then you are in a good place to go ahead and apply for a patent. And in a lot of scenarios, what you will end up seeing is that it is kind of borderline. So that is where professional expertise come into picture, wherein one looks at it, one looks at the innovation, and having all of this knowledge in the background kind of determines how do we actually position this whole invention in such a way that one, such objections should be reduced, and even when such objections do come in, we are in a very strong position to overcome those objections from the patent office, right? More from a practical standpoint, when we file any patent application for software inventions, one should definitely expect that the patent office will come back with set of objections relating to one or more of the 4 criteria that I just spoke about. So that is definitely going to happen. But that doesn't mean that we have to start worrying about it, right? So what we need to do is, when we are applying for a patent itself, we should position our patent application in such a way that when such objections do come in, we are in a strong position to actually overcome those objections. So that kind of brings me to the end of my presentation. So if you have any queries, I think this is a good time to kind of look at those queries and address them. So one of the questions is, what is the cost of availing the services? So when we talk about applying for a patent, there are multiple stages of applying for a patent. So the first stage could be what is called as a patentability study, which is an optional step. But typically in a patentability study, one uses certain paid databases. We use a certain paid database wherein we cover patent data from about 100 odd jurisdictions. And based upon that, we try and identify, are there any other patent documents from across the world which might be similar to what we are trying to protect? And based on that, we come back an opinion on whether the patent can be granted or not. And we also assess whether it might have challenges with respect to all these different aspects that I just spoke about, right? So for something like that, typical charges could vary anywhere from about 30,000 rupees to 50,000 rupees, depending on who you engage with. Then comes what is called as patent drafting and filing. Again, when it comes to patent drafting and filing, depending on who you engage with, it could, I'm talking about somebody who does a decent job. It could range from about 70 to 80,000 rupees, going all the way up to about 1.5 lakhs. Then comes what is called as patent prosecution, which is the patent offices will come back with objections, citing certain patent documents from other countries, raising objections with respect to different criteria that we just discussed, to which one needs to respond. So a patent agent who is representing you ends up responding to those examination reports. Again, you're looking at an expense ranging from about, let's say, about 35 to 40,000 rupees, going all the way up to about 80,000 rupees, specifically in India. So these are pretty much the major expenses that one could look at in terms of the professional fee. But when it comes to the government fees, if you are a small company, you would be either recognized as a startup or a small entity, and the fees are like highly discounted. So throughout the whole process, you are looking at an expense in the range of about, I would say about 6,000 to 15,000 rupees is the range that you need to kind of keep aside, depending on certain things that you would do during the filing process, so on and so forth. I hope I addressed that question.
Hey, hi Karthik.
Hey, hi, Sudarshan.
How long does it take for us to go through this complete journey?
Yeah, so when it comes to the timeline, if we are specifically referring to India, there are two types of processes. One is the ordinary process, the other one is what is called as an expedited process. So if you are a company or an LLP, you could either register as a startup or a small entity. And if you are a startup or a small entity, you can go for an expedited process. And if you go for the expenses involved in an expedited process is not much. It's again, roughly you are looking at an additional expense of roughly close to about 10 to 12,000 rupees from a government fee standpoint. No additional fee, so to say, from a professional consulting standpoint. So if you're going for an expedited process, applying for a patent, which is the process before we get into filing of a patent, could be, I would say if we are doing a patentability study, drafting multiple iterations and filing, we are looking at a month's time to complete this whole process. And once the patent application is filed with the patent office, you are looking at roughly, between 8 to 12 months to eventually get a patent granted in India in the expedited process. Whereas if we are looking at an ordinary process, we are looking at at least about 2.5 years. It could be, in the range of about 3.5 years. But at the same time, what we need to remember is that, a patent grant is not necessarily required for you to, make your technology public or go into the market. What is required is you should have filed for a patent application before you hit the market. Because once you hit the market without applying for a patent, then you lose the right to apply for a patent.
All right.
Yeah, thank you. So one of the questions from Avneet is, in which areas of software technology most of the patents are currently being filed? As such, I don't really have a statistics as to which fields of technology most of these software patent applications are being filed. But my guess estimate is that most of it would be in terms of application software as a service, so on and so forth. And if we were to look at the kind of work that we are doing, and if you were to try and gauge from that, I would say a lot of work is happening around natural language processing, machine learning, artificial intelligence. These are some of the areas where we do see a lot of traction in terms of the kind of work that we are getting. But as such, in terms of the broader statistics, I would kind of extrapolate and say that it could be around those areas.
So suppose we take a AI model and try to make a business application out of it, and let's assume it's one of its kind, unique, pioneering application. Can we consider that as a probable choice for patent?
Oh yeah. So let's say let's consider some kind of a web app that is being built out. Now, like the example that I gave, right? Let's say the flow itself is unique, and we can associate that flow to some kind of a business flow, right? And the uniqueness is actually in the business flow, not necessarily in the technology stack that enables that business flow, right? Then it becomes extremely difficult to get a patent. But if to enable that new business flow, let's say there is some unique aspect that you do in the technology stack itself, then that could be patented. At the same time, yeah, it is many a times it is like a one needs to kind of really look at what is that we are trying to protect, what is the objective that we want to achieve. Is there some way wherein we can position the whole patent application in such a way that it feels like it's the technology that we are trying to protect rather than the business flow?